Hello again friends, let's continue our gradual and slow and steady journey towards the conclusion of the discussion of the judgment in Re Delhi Laws Act given by the Supreme Court of India on the 23rd of May 1951. The previous video on this ended with this particular list. The provisions that were under discussion in this particular case. The Section 7 of the Delhi Laws Act 1912, Section 2 of the Ajmer-Merwara Extension of Laws Act 1947, Section 2 of the Part C States Laws Act 1950, and also the Federal Court's judgment in 1949 in Jatindranath Gupta versus the state of Bihar. That particular case had involved a similar situation where the executive had been delegated the authority to extend the act which was in force in the state of Bihar for a period beyond its original intended duration of 1 year. And in a 4-1 majority, the majority judgment, the federal court had held that such delegation of authority was ultra vires, was not within the powers of the legislature. The legislature could not abdicate its responsibility. Legislation was its sphere and it had to perform those duties. It could not hand them over to somebody else. And later on, of course, it was noticed that Bihar Maintenance of Public Order Act was not the only place where delegated legislation existed. It had also been in place in several other places. In fact, we have discussed one such delegated legislation provision back in the Brij Bhushan case. That seems to be the most popular video on the channel at the moment. So I'm assuming that you have seen that one, and you will notice that the Maintenance of Public Order enactment that was in place in Delhi that allowed the Delhi Chief Commissioner to put out a pre-censorship order against the organizer, that was also under a delegated legislation. So the point is, it was quite common, but the federal court had said that it should not happen, that delegated legislation should not happen. So the question arose, what are we supposed to do about all of these provisions? Are they ultra vires? Are they valid? Should they be allowed to happen? If so, what should be the extent of allowing delegated legislation? So let's look at each of these provisions one by one. Section 7 of the Delhi Laws Act 1912. First of all, do note the date 1912. This was much before the more enabling provisions that allowed provincial legislatures in our country, in our pre-independence history. If you look at the constitutional history of India, it began as early as the 1770s. Just while the United States was gaining independence, India was becoming more and more colonized, and at that time the British Parliament had started taking over some of the responsibilities from the East India Company. 1861 Indian Councils Act, 1861, that is after 1857, that is after the East India Company had been completely thrown out by the British Parliament, that the Crown had taken over the reins of India, and Victoria had become not just the Queen of England but also the Empress of India. After that, the Indian Councils Act of 1861 was passed, and any legislation that happened in British India after that date was under the aegis of that Indian Councils Act of 1861. And remember that that particular act did not allow for provincial legislatures or even for a central legislature. According to the British, the Indians had not progressed sufficiently for them to have such a legislature. So all laws were actually enacted by the Governor General of India, who also held the office of the Viceroy of India. And this Governor General, advised by his council, hence the Indian Councils Act, was the one who prepared all legislation, including this one. Section 7 of Delhi Laws Act said that the provincial government may, by notification in the official gazette, extend with such restrictions and modifications as it thinks fit to the province of Delhi or any part thereof any enactment which is in force in any part of British India at the date of such notification. So what does this mean? Supposing there is some law in place, in force in some part of British India, supposing the government of the province of Delhi feels that that particular law which is in force anywhere in British India needs to be a part of the statute book of the province of Delhi as well, then rather than going about writing a similar legislation, why not simply copy paste it over here, and not just copy paste it and pass it as different legislation, simply extend it to the province of Delhi. So that law exists, let's say, in the Bombay Presidency, and the government feels that that law should also be applicable in Delhi, then simply extend it to Delhi. Who can do that? The Delhi provincial government. How can they do that? By a notification in the official gazette. Does it have to be identical to that law in place? No, it can be restricted in certain places, in certain provisions of it can be restricted, certain provisions of it can be modified, and then that restricted or modified or absolutely identical legislation that was in force already in some other part of British India could now also be in force in the province of Delhi. The section 2 of the Ajmer-Merwara Extension of Laws Act 1947 is almost identical. As far as the semantic differences are concerned, they enter into the picture because of the date of the enactment, 1947. The Ajmer-Merwara Extension of Laws Act was not enacted under the aegis of the Indian Councils Act of 1861. That had been repealed in 1915. The law that came into force in 1915 had been repealed in 1935 by the Government of India Act 1935, and this Ajmer-Merwara Extension of Laws Act 1947 was passed by that particular provincial government of Ajmer-Merwara because it had been empowered to do so by the Government of India Act 1935. Now, the Government of India Act 1935 was the precursor to our constitution in every possible sense. There had been a federal structure in place, hence there was a federal code. There had been a demarcation between what laws can be made on what subjects by the central government and what subjects are available for legislation to the various provincial governments, just as we have in our constitution. So the Government of India Act was a huge step forward in 1935, and it allowed legislatures in the provinces as well. One such province was that of Ajmer-Merwara. Ajmer-Merwara is a part of Rajasthan. It is, well, basically the area surrounding the city of Ajmer, and this was a reasonably sized province. I think it was about 5 times the size of the province of Delhi. So larger than Delhi, much larger than Delhi, but not huge when compared with the rest of the state of present day Rajasthan. So anyway, the provision of the Ajmer-Merwara Extension of Laws Act, the very name should give us a hint what that enactment was all about. This particular provision, section 2, said that the central government may, by notification in the official gazette, extend to the province of Ajmer-Merwara, with such restrictions and modifications as it thinks fit, any enactment which is in force in any other province at the date of such notification. The difference is British India is not in the picture. Any other province where any law is in force in any other province, that law can be extended to the province of Ajmer-Merwara by the central government. So the province of Ajmer-Merwara, which probably did not have a legislature worthy of the name, would be helped out by the central government. That was the intent, that appears to be the intent of this particular provision. On the face of it, very similar to section 7 of the Delhi Laws Act that we just saw. So these two are pretty similar. They talk about any enactment which is already in place somewhere else, anywhere else in India. That enactment could also be now in force in this particular province, either Delhi or Ajmer-Merwara. Part C States Laws Act 1950 is slightly more complicated. The first complication is in the name itself, 1950. This was enacted after independence, not just after independence, but also after our Republic Day. This was enacted after we became a republic, after our constitution came into force, which is why something called Part C states existed. Now, we have discussed this a couple of times: Part A states, Part B states, and Part C states. Part A states were the larger states and the presidencies erstwhile. The provinces that today we call states like Maharashtra, Uttar Pradesh, etc., those were all Part A states. What used to be the princely states before independence, they were categorized as Part B states. And the smaller provinces, which used to be the chief commissioners' provinces, and the smaller princely states were grouped together to form Part C states. In one of our previous videos, I have discussed the province of Coorg, which was a Part C state in Colonel Appanna's case. That particular contract law case also had this discussion of Part C states. So Part C states, as I had mentioned in that video, you can think of them to lie in a tier between present day states and present day union territories. Not as small as union territories, but not as large as states. Therefore, Part C states themselves would not have legislatures worthy of the name, or would not feel the need to invest or spend money on full-fledged legislatures. So wherever any law needed to be made for a Part C state, if such a law was found to exist already in a Part A state, this provision allowed that Part A state law to be extended to that particular Part C state. On the face of it, that was it, but there were quite a few complications. So let's read through the provision. Section 2 of Part C States Laws Act 1950. The central government may, by notification in the official gazette, extend to any Part C state other than Coorg and Andaman Nicobar, or to any part of such state, with such restrictions and modifications as it thinks fit, any enactment which is in force in a Part A state at the date of the notification. Let's take a pause over here. So far, this is very similar to the Delhi Laws Act and the Ajmer-Merwara Extension of Laws Act. So far, this first part of Section 2 is very similar, and then enters a new complication. And provision may be made in any enactment so extended for the repeal or amendment of any corresponding law other than a central act which is for the time being applicable to that Part C state. So this provision, this complication, let's try and understand where it is coming from. What is being said here is that suppose while extending some Part A enactment to your Part C state, supposing there is a clash between the two, then what should you do? You are allowed to amend or repeal any corresponding law that was already applicable in that Part C state. So not only can you extend some other state's law to your state, you can repeal your state's existing law to make room for that new Part A state law. It sounds a little more complicated than it is, but these things are there just for enablement reasons, because the people who are actually going to do these things are well versed in what is happening. Unfortunately for us, of course, the court was going to treat these two parts separately. So the first 5 lines of this slide till the word notification form the first part of Section 2, and provision may be made starts with the second part of Section 2. Provision may be made in any enactment so extended for the repeal or amendment of any corresponding law which is for the time being applicable to that Part C state. So these were the 3 provisions that the President of India was worried about, and therefore he made a special reference number 1 of 1951 is its official title, and posed these 3 questions to the Supreme Court of India by using his powers under Article 143 Clause 1 of the Constitution of India, seeking the opinion, the advisory opinion of the Supreme Court of India. The first was that Section 7 of Delhi Laws Act ultra-vires the legislature which passed the said act? Question 2, was the Ajmer-Merwara Extension of Laws Act Section 2 or any of the provisions thereof ultra-vires the legislature which passed the said act? And question 3, is Section 2 of the Part C State Laws Act ultra-vires the Parliament? Do note the specific differences in each question. The Delhi Laws Act 1912, was it ultra-vires the legislature which had passed that act, which happened to be the Governor General of India? Was the Ajmer-Merwara Extension Act ultra-vires the legislature which passed that act, which was the Ajmer-Merwara Provincial Legislature? And finally, is, and not was, is Section 2 of Part C State Laws Act ultra-vires the Parliament? Obviously, Part C States Laws Act 1950 was passed by the Parliament of India because only the Parliament could legislate for Part C states, and therefore was this provision ultra-vires the Parliament. Just a moment to discuss what ultra-vires means. Vires literally means power or jurisdiction or authority. Ultra-vires, beyond the power, beyond the authority, beyond the jurisdiction. Was this provision that legislature had enacted, was enacting such a provision part of the inherent powers of that legislature, or was this enactment beyond the powers? Has that legislature exceeded its jurisdiction by enacting such a provision? These were the questions posed by the President of India, Dr. Rajendra Prasad, to the Supreme Court, and a 7-judge bench, all of them basically, sat and heard this case in the last 2 weeks of April 1951. When these hearings took place, and these hearings were unlike any other that the court had seen till that date, because there was no question of any adversarial kind of arguments. There was no one party versus the other. All the counselors that the Supreme Court bench was advised by, all of them were invited by the bench to help them out with this particular scenario, with these questions that the president had posed to them. And the list of counselors is longer than the list of the bench, believe it or not. The Attorney General of India, of course, was there, Mr. Setalwad. The Advocates Generals of Bombay, of Madras, of Mysore, all of them were also present, as were several other lawyers representing various parties who had been affected by those extended laws, either in Delhi or in Ajmer-Merwara or in one or two of the Part C states. Let's just take a good look at our bench. The Chief Justice Hiralal Kanya, of course, led it, and also sitting alongside him were his brother judges Sayyid Fazal Ali, Patanjali Shastri, Meherchand Mahajan, Sudhiranjan Das, Vivian Bose, and B.K. Mukherjee. They together wrote till that date the longest judgment written by our Supreme Court. Almost each and every one of them wrote a separate opinion, and you have to actually read all of them to figure out what was ultimately decided by the Supreme Court. And there was a lot of division. Almost each judge had a slightly differing opinion than what every other judge had, but ultimately we can summarize what was decided on this particular slide. It is called a cleavage of judicial opinion because there was a lot of difference, cleaving or dividing of opinion. The first thing they held by a 5-2 majority was that Section 7 of the Delhi Laws Act 1912 was intra-vires, that the Delhi Laws Act enabling legislature had not exceeded its authority when it passed such an enactment. 5-2 majority with the Chief Justice dissenting. The Chief Justice, Mr. Rather Sir Hiralal Kanya, and also Mr. M.C. Mahajan, Justice M.C. Mahajan, they were the ones who dissented to this. They felt that delegated legislation is not valid. Section 2 of the Ajmer-Merwara Extension of Laws Act 1947 was held intra vires as well by the same 5-2 majority. The same 5 judges held that this was also within the powers, well within the jurisdiction of that particular legislature. The first part of Section 2 of the Part C States Laws Act 1950, which as we discussed was very similar to those preceding two provisions. That first part was also held intra vires by the same 5-2 majority. But the second part, where the government, let's just recall what it was, that the central government may also repeal or amend any corresponding law which was for the time being applicable to that Part C state. That particular power was held to be ultra vires. What these judges, 4 of the 7 by the way, a very slim majority, the slimmest possible, by a 4-3 majority, they held that this provision of allowing the central government to repeal or amend an existing Part C law in order to make place for this newly extended Part A law, that authority could not be delegated by the parliament to the central government. The legislature which had the jurisdiction of legislating on Part C states was the parliament, and parliament had delegated the authority to amend or repeal laws already in place to the central government, to the central executive, to the Council of Ministers headed by the Prime Minister. And this particular provision, this second part of Section 2 of the Part C States Laws Act 1950 was held ultra vires, but by a very slim 4-3 majority. So as you can see, it is not a very straightforward discussion. First of all, it is administrative law, something which hardly any of us actually encounters in real life, unless of course you are already a parliamentarian or a parliament secretary or someone working in the secretariat. Other than that, most of us are pretty much away from this kind of legislation. That adds to the complexity. And secondly, all of these intricacies about extending laws, which part of which law, and so on and so forth, that makes it slightly a bit of a challenge to grasp in one go. Hence this immense division into so many videos, a division worthy of the cleavage that we saw of judicial opinion. So in the next video, which hopefully will be the concluding one, I honestly am not certain at this time, in that video or those upcoming videos, we will discuss how the bench arrived at the decision that it did, what were the arguments made, what were the precedents that were cited, and there were quite a few. And of course, if you think this video was not complicated enough, I urge you to read the actual judgment or the various opinions by that entire bench in the In Re Delhi Laws Act judgment given by the Supreme Court on 23rd May 1951. All the best. See you again soon. Take care.